Division chiefs. As a bureau chief, I'm not on the ground every day dealing with the issues. People like Paula, she's in the courtroom, the delinquency courtroom, and she deals with the issues on a day-to-day basis. One of the problems that we have, or we periodically see, and it's on a routine basis, you have a child who's delinquent, but there are some underlying dependency issues that really account for the problems he's having in delinquency court. For example, I have seen kids come to court on their own, catching 2 and 3 buses. They may be late, but they get there, okay? And this is a 14, 15-year-old. You have kids who come to court, and then you have the parents say in front of the whole courtroom, I can't do anything with him, you take him, judge. And I mean, talk about destroying a kid's self-esteem. So a lot of our delinquency issues, we find out that there are problems in the home. This kid is acting out for a reason. He's acting out because he's not being properly supervised, or there's a lot of mental and emotional abuse going on. Because some of the mothers, I could hit. You know, when you stand up in court and literally trash your own child and tell the whole world, I can't do anything with him. You know, so, you know, we have a lot of kids in that position. They're not bad kids, they just don't have any supervision. And they're doing the best they can with a bad situation. So one of the things that I talked about with her was, well, how can I teach my lawyer to be sensitive to this? Not just the criminal act. I know you have to deal with the delinquent act. But how can you be sensitive to some of the things that are going on in this child's life which cause these delinquent acts, all right? And that's when she came up with this brilliant check sheet that we're going to be using to help to sensitize my lawyers to these issues. Because as criminal lawyers, we forget that it's not just the crime we're dealing with the social environment that may have contributed to it or caused it, okay? Especially with children. They're a product of their environment. Now, one of my first-degree murder cases, I had a young man who was 14 charged with first-degree murder. He was with the Spanish Kings. But you know why he was with the Spanish Kings? Because they would give him dinner every evening and give him lunch money and send him off to school. He was assured of a meal and lunch money every day. So that's why he gravitated toward the Spanish Kings. They have a king and a queen. And the mom would cook every day. So it was easy for them to tell him, okay, you take the gun and you go in and shoot the guy, because if you shoot him, nothing's going to happen to you. If I do it, I'm going to go to jail for life. So you not only have these adults that are preying on children, but you have adults that are literally abandoning children, and they're doing the best they can in a bad situation. So I wanted my lawyers to be more sensitive to that, and some of the stories that I heard in my chief's meeting is what led me to that situation, to talk about that at the juvenile improvement, court improvement meeting. Now, I can
tell you that I think that I was a delinquency attorney for maybe 5 minutes before I ran into this dilemma, and it happened in a case that Ms. Hapner is on, and I had a young man who was charged with a serious offense. It was a first-degree sexual battery, and I could not get this child to open up to me. And I've worked with children for a very long time, but I couldn't get this particular one to open up to me. And I kept asking him, you know, tell me what happened, tell me what's going on with you. He just kept telling me it was consent, and he wouldn't tell me anything more. He wouldn't tell me anything else about how the situation arose, who this person was in his life, how they even ended up together, just nothing, nothing. He was a wall, and an angry wall. And he'd gotten in trouble for an order to show cause. The judge trusted for him to be released on an electronic monitor. And while he was out on an electronic monitor, he kept forgetting to plug it in, sort of, kind of, maybe. And in any case, he couldn't be monitored because it requires electricity, which he wasn't providing. And so he ends up back in the courtroom, and the judge was telling him, you know, I could give you 5 days, I could give you 15 days for every single time that you failed to plug in your monitor. And I know these young ladies over here are laughing about that because we have kids that look at 500, 600 days because of all of the different violations that they've accumulated. But in any case, when I was talking to him about how we were going to resolve his case, he was telling me that he's just going to do the time. And this is in the detention center. He's going to do the time. And so his only problem was, though, in doing the time was that his mother would not go to the detention center and pick him up when his sentence was over. And I thought, well, that sounds ridiculous. Of course she's going to. First of all, she's going to get a 15-day vacation from you, which it sounds to me like you think she wants, so she'd probably be pretty willing to do that. And so I'm having this conversation in his mother's presence, and I'm like, now, come on, your mom's going to come and pick you up, and then from behind me, I hear, "Noing!" And she absolutely, positively was not going to pick this child up. And I tried to get her to see her way clear to going to picking him up. She wasn't going to do it. He'd been in trouble for so many times, and she just was throwing her hands up. She was tired of it. I finally got the child away from her. We went into an anteroom, and I started to talk to him, and we were in the room for maybe 5 minutes, and he just broke down. He was bawling like a baby about how his mother had been trying to get rid of him since he was 2. And he genuinely felt that. And I'd seen a glimpse of it. And as the case progressed, I saw more and more and more of it. She came to court never for a regular proceeding, but she did come to testify against him. She needed to come and help bring a witness in, and a witness who could exonerate him on his sexual battery charge, but she couldn't seem to get the witness to court on the day that he needed to be there. She just never was very good at supporting him. And he really needed that support, still does. But we see these kind of cases all the time.
And that's how you can help us, because that child needs support outside of the delinquency system. Right. He needs someone he can talk to, because, we have a pretty heavy caseload. They have a pretty, and the 90-day speedy trial, we try to stay with that, so we don't have a lot of time to get to know the child, to bond with the child, be with the child. And that's what a lot of these kids need, is just some bonding time, an adult who can sit down and talk with them. Probably most of the kids, the longest period of time that we're going to be with them is during their intake interview, when they come for their initial juvenile intake interview. Or if they're in the detention center, we'll go out and see them and try to help them. But we just don't have the time to spend with what we call their social needs. Now, we do have a staff of social workers at the Public Defender's Office, but we're trying to use them in a manner where, in the more serious cases. So they have their own caseloads, okay? But if you could help us in that capacity, like gathering documents, talking to the child and finding out what's going on in that home environment, if there even is a home environment, And from the perspective of pre-file advocacy, just gathering the records, and you could make the call to the state attorney, or you could bring that information to someone in our office so we could make that call. That would be so beneficial, because we don't have the time. We're working on the criminal part of it, the delinquency aspect. And that's one of the things, my goal now is to get another pre-file advocate, because I know my division chiefs are stretched to the limit. They try cases, okay? Then they're supervising people below them, okay? So I understand that they just don't have the time to devote to those pre-file cases that I would like to see devoted to. So that's my goal, is to try to get another pre-file advocate like Lily. But that's a fight that I'm gonna have to fight. But in the meantime, you all can be that pre-file advocate for the child, okay? Even if they're in delinquency court, just like she said, there are so many things that you can help us with in terms of their social needs. Because I wasn't here, but everyone has commented on what Judge Starter said about a lot of these delinquency cases have underlying dependency issues. And that's where it starts, okay? If we could reach back, and we could go back and help that child out and get them through those problems, they wouldn't even be in delinquency court. But we need people like you to help us do that. Okay, so if you could assist us with the pre-file advocacy, if you could assist us with developing the mitigation for that child, or determining what's going on in the home that's causing them to run away, I mean, that's fantastic. Because we only have a limited amount of people that work on mitigation. And like I say, they are working on the cases in adult court, the murder cases. So you could be of tremendous help to our office. Because most of the time, that's what these cases are about. It's about mitigation, identifying the factors that brought this child into this situation. It explains a whole lot when you go to that house, or when you're aware of what's going on in that house. It explains that child's behavior. And prosecutors know that, but it takes gathering the information and then presenting it to them, you know. I don't mind groveling. Okay? If it means I can keep a kid out of adult court, my knees can be bloody every day. But when I get up off my knees, I will feel so good about myself because I have kept a child out of the adult system. And more importantly, I've identified the problems that brought the child into the system, be it a delinquency system or the criminal justice system. So the work you can do is invaluable to the work we do, because we need to get to the source of the problem, okay? We need to keep them out of adult court, and we need to identify the issues that have brought them into the delinquency program.
I do have one other story, maybe something that people might encounter. It's another delinquency case with the sexual battery involved, a pretty heinous sexual battery. And something happened during the court proceedings which really could have I think my child would have been so much better helped if he could have had somebody else, a guardian or somebody else in the courtroom with him at the time that this happened. He was charged with the sexual battery on his incapacitated older sister. And his father had found out, it was the only living parent, and he was distraught by what had transpired in his home. And from that moment of discovery, he rejected this child. And that crushed this child more than anything, more than the investigation, more than what he'd done. Just to be completely rejected by his father just really crushed him. And he knew through the proceedings that his father had come into court. He talked to the judge about how to terminate his parental rights. I mean, this father was just in this child's face about the fact that he was rejecting him. And not that that isn't bad enough, but during his trial, which was horrific, there was videotaped evidence. It was a horrible trial. We took a break, and during that break, a case manager from the Department of Children and Families came in and started to interview him regarding the father's desire to surrender in the middle of his trial. He really could have used somebody other than me, because I was very focused on his criminal case, to be sitting right there and to kind of walk him through this process that was about to happen in his life, where he was about to not only lose his freedom, but his family. So you could run into something as devastating as that as well. And these kids just really, they're kids. They're kids. And many of them are teenagers too, and so they have all of the problems that teens are faced with. And then they come from some pretty dysfunctional households sometimes. And so, you know, compounding the problems makes it even worse. So they need as much help as they can get.
Yeah, and one of the things that I see happen a lot in juvenile court in terms of supervision, I see grandmothers now that have to assume responsibility for a teenager, and they're not equipped to handle that teenager, and you know the parents are in jail or on drugs. So, and that's another factor. You know, we at the intake interview, we can usually identify the children that are going to need your support. And I say that because that's in addition to the legal support we can give them. You can give them moral support, okay? So we can usually identify those children quickly and get you the message, can you help me here with this one? This is going to take a lot of hand holding. I'll take his right hand, you take his left, and we can walk him through this together. Because some of the stories that the children tell you, it's horrific. If you know, the ones I deal with, I have them for 2 years, okay? When you charge with first-degree murder, it takes a long time to prep that case, okay? But when you charge with sexual battery in juvenile court, they're not gonna give you 2 years to process that case. So we need people who can help us with these children on the social end, the mitigation stuff. Because we always tell our lawyers, you need to start developing mitigation from your very first meeting. There's the trial, and we have to always be prepared for the mitigation. I don't assume I'm gonna win every case I say I'm ready on. So we start preparing mitigation from day one. Okay, it's not that we don't believe the child, it's not that we don't believe in the case, but we have to be prepared to go forward whenever the judge renders that verdict. And that's going to be right away, unless you set it over for a disposition hearing, which is only 30 days, so you don't have that much time. But your input at pre-file or during trial or prior to disposition can be invaluable in terms of helping us prepare the case for mitigation. Okay? Any questions?
Can I throw something out there?
I want you to come up here because she's a great. I want you to come up here. She is.
I don't have a war story, but.
Well, we use her with our hard cases, our really hard cases, our mental health cases, and those are hard cases.
This is so exciting to have the option of you guys to support us. I just think, I think all our lawyers are effective and work hard, but just another judge seeing you guys in the courtroom on behalf of a kid will change the whole dialogue. Judge Rice complains that her parents don't bring kids to court. They're sleeping on the neighbor's couch. And what's she supposed to do? And it's very difficult for us to dig deep. But this is what I was going to say to you. Everybody's alluded to it. There's no accountability in the system for the people that take care of our kids. Our kids aren't great. They're not good. How are they going to do it on their own when you have a 13 and a 14-year-old? They can't get themselves to the courthouse. They can't make their appointment with the mental health specialist, okay? So let's assume they're even cranky, bad, or don't do the right things, but where is that support system to get them to do it? And in my experience, the accountability factor, all you have to do is ask the clinician, he didn't go to his appointment, so now he's going to get a violation of probation. So then you say to the JPO, well, what did you do? The judge will ask him. They'll say, well, I gave him the referral. So then you look over at the family and you say, well, what did you do with the referral? And the mother said, I made a phone call. And it never gets to the root issue, and it really had nothing to do with the kid not getting there. And so I find that if you can just dip underneath the surface, and lawyers call it curiosity, some of my favorite lawyers, ask that question, what did you do with the referral? And then you learn that there was no follow-through, no follow-up. And I don't go after providers. I don't go after the school system. I ask questions, and I say, well, how can we do it to get that service to them? And frankly, by the time you get that to the judge appreciates the fact that people are working together to support that kid. So I'm not the enemy of the system. I'm not the enemy of the JPO. I walked into all right, I will tell a story. We have a kid in the juvenile system right now in front of Judge Stoddard, which is a joy to work in front of him, but he is mentally retarded and incompetent to proceed due to mental retardation. Well, the school system, we fortunately had some agency in court that says, well, he's being in the school system as a behavioral kid, an EBD, emotionally behavioral disturbed. And that's not true. He's mentally retarded. But he's being put in an exceptional school where kids fight all the time, and he jumps into fights. And they'll tell you, he doesn't start the fight. If people are fighting, he'll run from the school bus all the way to the front of the school just to swing a punch, okay? So he's on his third felony in 2 years, which actually is pretty good if it took 2 years, all batteries at the school system. And they keep bringing him to the juvenile justice system. So we noticed this disparity that he's not being taken care of as mentally retarded in the school system. So I tried to attend what I thought was a multidisciplinary staffing. It was an expulsion hearing. And it was disgusting to be part of it because for 2 years, the schools got him down as a Sandy Hook crazy man, and they said they've done everything they could to address his issues, his behavioral issues, knowing he just jumps into people's fights. I mean, they have done things like he doesn't read or write, guys. He's sitting in a school every single day. He doesn't read and write, okay? And so we're going to continue to educate him when he has no self-esteem. His mother's rights were terminated. He lives with the grandmother until he was found mentally retarded in the criminal justice system, and now he lives in an APD group home. Okay, so imagine the spiral of his life. So he's gone 2 years in the school system never addressing his actual needs, getting into trouble, to the point where they file charges. His whole criminal record is that he's bad in school. And then I go to school and having no idea, I've sat in an expulsion hearing. And so the expulsion hearing had 2 things I had to prove. That what he did wasn't related to his disability. And on paper, that's exactly what it was. He's EBD and he's evil and he beats people up. And they had to prove that they did everything they could, that there's no way the school system failed him. And they didn't even have him adequately. So at the end of 3.5 hours, I said to them, why? They agreed that they could do more. They can psychologically test him and put him in appropriate level school, blah, blah. And that's why he's in some of this trouble. But I said, why did we just spend 3.5 hours doing this if that's the case? And they said, oh, because he got another charge, so we had to have this meeting. And I walked out with somebody who said, if you didn't go, because I'm a lawyer, he would have been expelled. And, you know, I'm still in my job after all these years because I'm naive and I'm not cynical. And I'm going to still walk into a staffing like that and say, why is this happening? But you know what, guys? I think that kid might be broken, okay? It's 2 years that he's had no behavioral training to not be what he is. I mean, if they have let him get to that point where he's really out of control. And when I said to them, do you realize that he is of the age where he could be direct filed as a felon in an adult system and go to prison because he can't fight his way out of that jail cell? They didn't even care. It really, I'll tell you, it's hard to see these things. And all it does is require you to ask one question to crack the surface. That little bit of curiosity to sit there and say, oh, we have him mentally retarded, but he's not mentally retarded in the school system. You don't take a pill and your IQ go up. That's a developmental disability. He's had that since he's 0 years old. So if you didn't ask that question, you don't get to that point. And if you guys are in a position to be an advocate for those, if you just sit and listen to a kid and you got your eyes and your ears open, this stuff is everywhere. And we don't have to fight against people to do what we can for the system. We can fight with them. And I just to say, if you want to just come to detention hearings any day, I had been in juvenile for a long time and I kind of went back, and sitting in a detention hearing is just a family in crisis. Right. These kids are having a problem at home and they end up arrested on the family calls the police as their resource, and then what's the police officer going to do? Take them into detention. And so if you're outside of the system just looking in, come to detention hearings, because you aren't going to be jaded the way everybody is jaded and just running these cases through the system. You're going to sit there and say, wow, you know, that family's got a problem. The father just walked out. The mother is totally stressed out dealing with 4 kids. He's not doing good in school. Boom, call the police. And now we're starting the delinquency process. And then the providers drop cases when they're in delinquency because delinquency is going to fix the problem. And it doesn't fix the problem. So these are the kind of things you run into. And just by your curiosity asking questions, ladies, gentlemen, we're all human beings. You just sit and talk to a child. And you're going to know exactly what you need to do. You all have clients out in the civil world. You talk to your client, it just kicks in that instinct of what kind of things I need to do. And we're human beings. It's going to come to you. And we're a resource to anybody because we're fighting what you're fighting. But to think that you could be that extra set of eyes and ears, and I actually have my first one that I'm working with. This kid is in a level 8 program. He's lived in juvenile commitment programs his whole childhood for the last 7 years. And now they want to bump him to a 10. And I don't even know how you can live in a program that long. So I'm not that good with delinquency, which is kind of like where you guys are going to be. That's weird that you're in a delinquency program for all these years. And, you know, you just start to ask these questions. Well, the father doesn't want to take him home. So I said, well, how does that equate to 7 years? Doesn't somebody in that period of time sit and say, can somebody speak for this kid? Can we get him into a SIP placement or somewhere out in the community? Because if your dad and mom's dead, which is why he got into the charge he got into. He hit somebody in horticulture at their level A program. He hit somebody with a shovel because they were mocking him because his mom's dead. And he's got a father so the judge appointed a attorney ad litem on that case. And I called him up, and he had never handled the case before, and I left him this long message. Oh my God, I'm so excited you're on this case. I can't wait to hear what your perspective is talking to this kid, because I need, clearly something's wrong. The system shouldn't be the delinquency system doesn't raise children in the state of Florida. So, I think you're not going to have any problem walking in there and smelling what you need to do, and just work with us, because we will be the best delinquency advocates, and all you could do is be an amazing asset to a case.
And I think that's why I was so happy to work with this program, because most of the children need wraparound services. We just can't deal with the delinquency aspect. We have to deal with the whole child, the whole problem, and that's usually a family problem. Okay? So whatever help you can give us, it's most appreciated, and the children, our community will benefit from it, because these children are so starved for attention. Any attention that an adult gives them that is positive, they have a high. They transform. Just the mere fact that an adult showed them some positive attention, because normally all they get from adults is very negative. Okay? And when they have an adult who is not a family member, who shows them some positive attention and takes interest in them, it changes their whole demeanor. I have seen children blossom. One example I have of a young woman charged with first-degree murder. She stabbed a man 70 times, but she had been sexually abused by her family members all her life. Right. And while in jail, a female minister gravitated toward her and started working with her, and this girl's whole demeanor changed. By the time we went to trial in 2 years, she had blossomed. The judge couldn't believe it, and eventually the judge gave her a very good sentence after trial, but now she's out, she's living with this guardian, and she's active in the church. But I saw her go from this overweight, angry girl to a beautiful young woman who's very articulate, because one woman saw something in her and decided she was going to devote some time to her. Now, most people wouldn't want to touch somebody charged with that kind of crime, a violent crime like that. But that girl was transformed, and all it took was one adult who took some interest in her. Okay? So that's all we're asking. We're not asking for a lifetime commitment like that lady did. But you'd be surprised. A month, 2 months, just some adult who takes an interest in them, and they realize this person wants to help me. They think enough of me to come out here to see about my needs and to assist me in accomplishing the things that I need to accomplish. That says a whole lot to a child. Okay?
Can I just say one thing that's really obvious? But I feel like I need to say it out loud because I have to remind myself of it maybe. There are going to be times when you're going to have just real success stories like the one that Ms. James talked about. And there are going to be other times when you're going to really feel stung by what's transpired in the case that you've worked on. Keep going.
Remember the successes.
Guys, in the case where I had the kid in the school system for 2 years where nobody did anything through the school system, and all of a sudden I'm listening to them telling me that they're in fear every day, that they're in the same school, and I said to him, how does this get to this point? This is terrible. You're frightened of him. He's not getting educated. And I said, is there no way to prioritize addressing his issues? Dead silence in the room. So then the Agency for Persons with Disabilities, who takes care of the mental retardation aspect of this case, because he's in a group home, said, ma'am, don't you know there's waiting lists and everybody's doing the best that they can do? And I said, that's not good enough. You know, it's crazy to me that they're gonna be there in fear. This kid's not getting educated. You're gonna tell me that a waiting list is gonna get in that way? The minute you start asking questions, how do I get an exception of the waiting list? How do we prioritize this case? This is a Sandy Hook case, or this is a kid that you've totally failed case. There's an exception to every rule, and the whole system just plods along the way everybody does it. And what you can bring to the table is that curiosity to say, you know, the definition of insanity is doing the same thing over and over again, expecting a different outcome, where all you did was sit and say, is there no way to prioritize this case? Or just flat out tell them, that's not acceptable. We need to do this now because we're continuing to break something that's already broken. So even in that sense, for you to expedite things, for you to get the gig is up, you know, when you hold people accountable, they don't really have a choice. A lot of these, our office goes after providers all the time to serve our clients, and we're involved in that whole collaboration because we've got a microscope on what they're doing. So if they say they're going to do this, well, they need to do it. And if they don't do it, we politely say, well, what's going on? How do we do it? And that's basically what you're doing. Once you put them under a microscope, well, guess what? They have to do what they're supposed to do. And, you know, that's policing the system. It's not to ask them to do anything more than what they're supposed to do in so many of these instances that they won't do if nobody's watching.
And the woman that worked with my client she was a minister, but when they know you're a lawyer, I mean, it's like the whole room, oh my God. You know, if anybody can hold the system accountable, it's you. Just by the mere fact that you're a lawyer, they know you're going to ask hard questions and you're going to want answers. That's why you're there. Because nobody has held them accountable. They just plod along, you know. And so you are there, and when you step into that room and they know you're a lawyer, it's like, oh my goodness, somebody is finally here to hold us accountable. And that's just your presence. Everything changes. Okay? You don't even have to open your mouth. Just hand them your card. Okay?
I think that's why we all went to school, right? I mean, we could all have been social workers, but you don't have that advocacy piece that you have sitting here as an attorney. It's a beautiful thing.
Not for me.
All right. Thank you.
Allison Singer, if you don't know, was in the PD's office. She's now in the city attorney's office. She is a co-founder with me of Crossroads, and she had an experience recently that made me really want to have this AAL program be a part of Crossroads. When she got called in to help a youth, and I'm going to let Allison, say what you can about it.
Sure, yeah.
It's an ongoing
case. It is an ongoing case, so there are some things that I can't really share, but what I can say to echo exactly what Marie and Theta and, is it Paula, is that right? I'm sorry, I'm just meeting Paula. We're sharing is, it's very layered, you know? And what happened was I got called by an assistant public defender to say, hey, there's a kid in my courtroom and the judge would like you to come in to see if you can do something to help. And you have this moment where you say, well, yes, I'd love to help. What do you want me to do? Exactly. Because he's being represented right now in the criminal case, and that has been what I have spent the last 2 months figuring out with my kid is, what am I going to do? And that initial meeting is not always when you're going to figure out exactly what you're going to do. It has taken 2 months of meetings and phone calls and meeting other family members and getting documents and really learning about the layers of my kid and his family, because that is sometimes a really good tool. Sometimes not. Sometimes there's just nobody to talk to, or they're not willing to talk to you or whatever, but sometimes they are. And if they're willing to talk to you, talk, because they are a great resource as well about, even if you're just getting their perspective, right? And even if it's completely different than what your kid is telling you about what's going on, you need that perspective to be able to put all of the layers together and to figure out what you can do, right? Because what's happening with my kid is he's got criminal representation. Actually, that case is resolved now. And he's also got representation in another matter that's going on that I can't talk about. But we were pretty clear that there were some other unresolved issues that he was going to need some help with. He just wasn't necessarily able to tell me what those were specifically at the outset, and neither was anyone in his family. And sometimes that's because they don't know that other options are out there, right? Sometimes they don't know, for example, oh, I could be getting a check for SSI or SSDI, or, oh, I could be getting Medicaid, oh, I could be getting ... All of these sorts of things that maybe you don't know initially either, but that you can learn along the way as you ask the questions and as you figure out what those needs are. You figure out that you can address a lot of things that will suddenly make some of the root problems a little easier for, first and foremost, your kid to deal with, but sometimes by extension also the family to deal with, right? Because think about something like Medicaid, right? If you don't have insurance for your kid, then what do you do when the kid gets sick? Sometimes you don't go to the doctor, usually you go to the emergency room, right? And I mean, if you go at all, right? Sometimes the kid's not getting medical treatment at all. And finding out that not only can you get Medicaid, but that there's somebody who will help you get it, changes, obviously, the medical options for the kid, but it also might change their criminal case options and then any other civil case options. Because sometimes, for example, your kid in a criminal case will be on probation, and one of the things they'll have to do, depending on what the charges were, they might have to do random urine screens, for example. They might need to go to DACO, these sorts of things. And what you'll hear over and over again from different families is, we don't have the money to do that. We can't do that. And if they don't get told, wait, it's okay, because number one, DACO has a sliding scale, and number two, if you have Medicaid, you're going to be okay altogether, then sometimes you have a non-compliance issue, which leads to a violation of probation, which leads to ... this recurring cycle. So a lot of times, I mean, it's really just echoing what other folks have said. Keep asking the questions, keep digging, and keep going in general, because initially, my kid didn't want my help. And so it was a matter of building that rapport and going back and calling and spending lots of hours, first of all, to make sure they know who you are. And that's something I think we'll address in another training as this develops a little bit more, and what your role is. But even what I'm saying, I guess, is even when you're not exactly sure, hang in there and keep asking the questions and keep going back, because sometimes your role will get a little better defined as the relationship progresses and as you learn about what the child's needs actually are that you can help with legally. And what I was sharing with some folks at the table is you're probably going to do a lot of non-legal work too along the way, because that's how you find out the answers to these questions, right? You go to lunch with your kid, or you paint toenails with your kid, or whatever it is. You do some things that help your child understand that you're a person and they're a person, and you want a relationship first and foremost. And once you have that relationship, that sort of unlocks the doors for you to be doing the legal work that they need as well.
Thanks, Allison.
Sure.
What we're all alluding to, and for the attorney ad litems who are here, for those who don't know about the attorney ad litem program, it's a well-established program. When Judge Ashley Moody was in delinquency, she began recruiting attorneys to come and spend time with children whose parents or guardians were not showing up for their delinquency hearings. And that list grew to, I think at one point, it was close to 100 attorneys. And so this still exists, and Judge Moody and her JA kept this list even after Judge Moody was in criminal court, no longer in delinquency. Well, she asked me if Crossroads would take over the list, the attorneys, and bring those attorneys into our pro bono program, which is an advantage. One thing for sure is that you're protected with professional liability insurance under our program. Always a good thing. And so we thought, especially after talking to Allison and seeing how she was helping this youth in delinquency with a guardian who didn't seem to be around and other issues, was what if we had a checklist that you could use when you go and you spend time with the child at these delinquency hearings? And Ms. James alluded to that. and thought that it was a good idea. I talked to Betsy Hapner, and she is an AAL who goes beyond just spending the time with the kids at the hearings, and she told me about that. So what we would like is for you to have a tool, the AALs, to have a tool when you're talking to your kids to elicit civil legal needs, things that they need that we could help them with. May not be you may not be equipped to handle it, but you are going to make note of these items. And when there's a hearing, you can let the judge know about them, but you also can come back to me at the Crossroads program, and I can find another pro bono attorney to help the child to get what the child needs. And that can be educational needs, that can be ID cards, it can be a variety of things, and Betsy is very well versed at this. So what we're doing now is we're completely developing the checklist. I have been talking to judges, I've talked to different stakeholders, the PD's office, to Betsy Hapner and others, and now I'm going to talk to the judges again, and we're going to get the final procedures in place, and then I expect to have a meeting for the AALs sometime in March, maybe towards the end of March, when we'll talk about the new procedures. And Ms. James, I remember when I talked to you about this some time ago, you said that you thought that former PDs would be great for this program because we may well be looking for more AALs to work with these kids. And I think that's a great idea, so I'm going to be calling you about that. Okay, that would be wonderful. No, I'll be glad to do it. Okay. Next speaker is Walter Hahnemann. He's the supervising attorney of the Children's Advocacy Program at the Legal Aid Service of Broward County. And we're honored to have him here today to talk about dynamic duos, how civil counsel and defense counsel work together for crossover youth.
I got myself into trouble by having to do an email for an emergency, so I got put into the, it's quitting time on Friday. So, oh, we have another speaker. Oh, good. Well, then I'll do it. All right. Judge Stoddard, was it? He said, he used the word infrastructure about our youth, and let me just start off by saying, I think that's what it's all about. We've heard so much, but it's the infrastructure of our future. It's our human infrastructure. We put a lot of time and money in our nation and in our state and in our communities, putting money into other infrastructures, but we fail the infrastructure of our future and of our children. And if you think, or anyone that you work with, or anyone who wants to become an attorney ad litem on a pro bono basis, for 1 minute thinks that these are just other kids. These are the kids, if they're not your own blood kids, they're the kids who go to school with your blood kids. They're the kids who are in sports teams, who go to music concerts, who are on Facebook, who share the dreams and share the sorrows of your own blood kids. So they are our community. And when we start drawing lines and distinctions about it's not my community, that child belongs to another community, another neighborhood or whatever, then I think we are failing ourselves because we're selling short the development and the caretaking that we are all obligated with of our own human infrastructure. Enough of that. As an attorney ad litem, what I've been asked to talk about is what are some specific things you can do to help when you're representing a youth in dependency. What can you do in the delinquency system? So I've structured it a little bit to kind of chronologically, and the first thing is in the beginning as delinquency prevention. You're going to have youth the youth that you represent. And you can, the obvious, it seems obvious, but I'll say it anyway. Don't forget to counsel your client. Counsel your youthful client on what is a delinquency act. What can be charged as a delinquency. Sometimes they don't know. And also you need to be realistic and say, look, the reality is if you're walking down the street in this neighborhood at 10 o'clock and you're an African-American male, guess what? Popo going to stop you and say, what are you doing in this neighborhood? And it's going to lead to a problem. You can be realistic about that. So counsel your client of what some of the what they need to think about before they get into trouble, before they have a fight, before they feel obligated to, not obligated, before they get into trouble. Talk to them about drugs in a very frank way. A lot of our youth, if they're old enough to use drugs, they're old enough to have a frank discussion about it and the illegality of drugs. A lot of kids, it's just weed, it's just alcohol. It's still illegal in the state of Florida. So counsel them on that. And running. Running is a big problem because youth run. They usually, my experience, and I think there's some studies on this, I didn't bring the studies on it, youth don't and care tend not to run from something. Very often they are also running to something. They're running to family, they're running to extended family members, they're running, they may be running from a bad placement, but they're also running to something. And we need to acknowledge that youth are not always going to run. Not always stay put. We also need to look behind what a run is. I have some group homes that are obligated to call in and abscond when the child is gone for 15 minutes. And that includes when the child is literally at the end of the street. They can see the child, but the child is gone for more than 15 minutes, so they call in and abscond. But talk to them about it, about the dangers of running, and also the dangers of when you do run and you got no place to go, and you're not even couch surfing at best, but you're literally on the run on the streets, that puts you at risk for picking up charges. And also, as you get to know your child's placement, you may realize, you may learn, you'll hear through the grapevine, certain placements, I can't speak directly for Tampa, but I'm sure it's the same. Certain placements you're more likely to get a charge. And there are some shelters, especially at the shelter stage, when youth are first removed or they're between placements, they've been removed from a foster home. The foster home gave a 30-day notice, which is a nice way of saying you can't stay here anymore, or the group home gives a 30-day notice, you can't stay here anywhere, and they go to a shelter. In between shelters often are times when youth are at great risk of picking up charges because there's fights, there's absconding, there's drugs, and you can talk to your youth. You can also talk to what your role. One of the things you can do, your role as an attorney ad litem, is say, look, I know my client because I've gotten a rapport with them, and I know that if you place him at this placement, it's not going to be good, and there will become delinquency charges. Ask for it. If you have a good rapport with your delinquency judge, you can even ask the judge to make a finding. They can't tell the department specifically in lateral moves where to place, but you can say, please make a finding that placement in such places as shelter X and shelter Y and shelter Z would not be in my client's best interest. Or if they're in a current placement, you can say, Judge, I'd like the child not be removed until there's further order of the court with a hearing, so that you know where your child is being placed. The other thing that you can do up front, that's prevention. The next thing is if your child is taken into custody / arrested, that kind of taken into custody, is to avail yourself of diversion. And I'm not sure about the civil citation status here in Tampa, but all throughout the state of Florida we have diversion programs. And typically the public defender's office is not appointed at that stage because they're not appointed until the detention hearing, and this is all pre-detention hearing. And in Florida, the law allows the prosecutor, the state attorney's office, the sole discretion to decide whether they want to send a case to diversion or not. That's where you can go. And my chief juvenile prosecutor in Broward is a wonderful person, a wonderful prosecutor, because she understands. She gets it. She gets that kids, especially in care, come with all sorts of baggage, and it's going to manifest in sometimes maladaptive behavior. But she laughs when she sees me coming, because I do what I would encourage you to do, and what you've been told over and over today. I've heard it said so many times. You give the information. You go tell the story. So I go, oh, Maria, I want to tell you the story. and I tell the story without revealing information which necessarily could be legally harmful to their case. I mean, I just say, look, the police affidavit says the following, it's alleged, and you can just say it's alleged that this. But if you can tell the story of not only what caused that allegation to take place, but also I found more importantly, tell the story of what services the youth has, can have immediately, and will engage in. Because what is the state attorney interested in? The state attorney is interested in the child somehow mitigating their circumstances, not reoffending. That's what diversion is all about, to cut down on recidivism. So go to your state attorney. There's usually one person who is in charge of sending cases to diversion, or whoever the decision maker is for sending a case to diversion after the arrest is made, and go talk to them about the services. I'm very successful with getting cases sent to diversion that otherwise would end up being filed judicially in court. And tell the story, get the services in place. And an example would be, if I have a child who picked up a petty theft charge, and I know that they're in a group home, and I know that the group home is problematic, and that the child came from a home, was removed from parents who never clothed or fed her, and that I have individual counseling and group counseling in place, I'll go to my prosecutor and say, look, my kid got arrested 2 days ago. You're probably going to see this when it comes across your desk. I want you to consider it for diversion. Here's why. She's 13. It's her first charge ever. We have services in place for her. We've just arranged for her to start attending a good school, an appropriate, not good, but an appropriate school for her. We have all these services in place. This is appropriate for diversion. And you'll find that's very successful. Again, just be careful. You're not admitting anything to the prosecutor because they're going to use that. Be careful in that, but just use your common sense and say, look, this is what's alleged, that she took something, she took food, whatever. Also look behind what it is, what the charge is all about. And I'll get to that too. We've heard that. Look behind. You don't get a trespassing charge at 3 in the morning just because you're trespassing. It just doesn't happen. There's something else going on. So address those issues. Also with diversion, sometimes your kids, when they come into care, may already have a diversion charge, or they came into care, they were offered diversion, the case is being kicked back. In other words, it's being sent back to court because they failed diversion. Sometimes they failed diversion because they were with a parent who never supported them and giving them the notices, giving them the mail, telling them you have a diversion meeting, or driving them to. And sometimes the department also does not do that. So I've had a lot of youth in care that got transferred from one caseworker to another caseworker. The notice of the opportunity to go to diversion, you sign a waiver of speedy trial rights. All those documents were sent to someone else. They don't get sent in, or the child's not driven to the diversion program, and then they get bounced out. So figure out what the problem is, who's not driving them to the diversion program. Go back to your prosecutor and say, don't send us back to court. Let's fix the problem and let's make diversion work. Okay. And again, I have some concrete examples. I was asked to give concrete examples. Brittany was a girl I represented. She had a diversion charge that was sent to her mother, but she was also being removed from her mother because her mother was neglectful and abandoned. So that's a perfect example. She didn't know that she had a diversion opportunity because mom had all the documents on the beach in Havana somewhere. Literally, she went to Cuba for. She thought it was all right to go to Cuba for 2 weeks without telling her daughter. So ask for rediversion. Okay, because that's if you complete a diversion program, by the way, you can then file with FDLE to get that diversion record expunged and the arrest record expunged as well. And then that just keeps a clean record for the youth. If they're charged, There again, and I think this is kind of getting repetitive, you've heard this over and over, but reach out to the public defender and give the public defender the information that you have that's going to help. The story. What's going on? You know? Do you really want to prosecute this as, go to the public defender and say, look, the charge is an aggravated battery, but when you talk to her, you'll hear that this is a group home. This comes from a group home that has had 10 arrests in the last couple of months. It's always involving the same staff members. Let's put the pieces together and see really what happened. Because sadly, some of our group homes do include in their interventions calling law enforcement. And I'm not suggesting at all that no group home should ever call law enforcement. But as some of their therapeutic intervention steps, pretty low down, is calling law enforcement, making a referral to law enforcement. So get that information to the public defender's office. Give advice on what supports they get in the dependency and also what supports you can get them in the dependency system. Go to your dependency judge and say, look, the child needs substance abuse services, if the child consents. You know, talk to your kid, and if they say, yeah, this is what I want, go get it for them. Make it happen in the dependency case, and then you can get that to the public defender's office, and they can use that to the benefit. Causes and the stressors. Also, reach out if they're already on probation. Reach out to the JPO. Talk to the JPO. I had a youth. I'll just call him KO. KO was charged with a rather serious sex bat, but I was able to work a deal with our public defender. I went to our public defender and I said, look, here's the story. Here's the horrific background that this young boy came from. Here's why he perpetrated against his sister. And the answer for his boy is not placing him in the juvenile justice system in a delinquency program, a commitment program that probably does not address his specific needs, but will address substance abuse or whatever, which was not his issue. And we got him placed in a dependency program specifically for youth, boys with sexualized behaviors, and cut a deal that the terms of with the public defender, cut a deal that the terms of probation were just successfully attend and complete the program. State agrees to it. Now, we're lucky in Broward because we have not only a designated public defender for crossover cases, we also have a designated prosecutor. It's the same two people all the time. And so, and all our judges who have a crossover specific morning or afternoon just for their crossover cases, we have a designated defense attorney, a designated PD rather, and a state, and they understand it. We also have designated crossover JPOs and caseworkers. That's all they do. It's just our crossover cases. But if you don't have that, you can still take that information and say, look, I can get the child in the dependency world into a specific program. I can get this therapy. I can get the anger management. I can get all that. One, it's appropriate for that child's needs. And number two, it's not duplicative, because you're going to have all these dependency services and then the child's going to be asked to do all these delinquency services. And it becomes overwhelming for the child, and it becomes overwhelming for the adults who care for the child, or the adults just don't drive him to all his services or her services. You know, and my boy KO also then got picked up with some weed in his pocket, because his camera's running, I shouldn't say this, but if you had been through what he has been through and struggles with daily, he came back into care, by the way, because his father whipped him with an electrical cord so severely he was in the hospital for 4 days. Luckily, he was arrested for stealing food. And when the police showed up, they tried to cuff him. They realized they couldn't put the cuffs on his hands because they couldn't get his arms and his hands behind his back because they were so swollen. Credit to the law enforcement officer. A law enforcement officer didn't say, I'm going to arrest you for stealing food. The law enforcement officer said, why are your hands like this? What's going on? And so he came back into care, and he then got a possession charge for some marijuana. And before that charge even got to the prosecutor's office, I went with my public defender to the prosecutor's office, and you can do this, and you can say, look, this is the charge you're going to see. In his dependency system, we've added substance abuse to his ongoing weekly therapy. So by the time it got to her desk, he was already in substance abuse counseling. It was incorporated into his weekly counseling. In the most severe cases, sometimes where your youth who has been charged and is looking at commitment into a DJJ commitment program, moderate risk or high risk, sometimes you can look for alternate placements, such as this residential treatment program, a residential program for sexualized behavior. I also have some youth who do in the dependency world meet the criteria for placement in a residential treatment center for emotional disturbances, mental health disturbances that are severe enough. And they're also looking at the real possibility, and we don't do this lightly with the public defender, but work with your public defender and look if there's a real possibility that they could end up being sentenced and being committed. And if there's no defense to the charge, and sometimes there's not, and it's, or there's so many charges and they picked up another charge, and you know that the judge is going to commit to a juvenile commitment program, you can also, and the dependency system wants to place him in a residential treatment. We're blessed, we have local residential treatment centers. We'll work that out too. And the prosecutor's office, you go and you say, look, don't make it duplicative. Send him to one program in the dependency system and have that be his special terms of probation, attend and complete that. And if there's any special issues you want addressed, anger or whatever, they can be addressed. And don't remove him and place him into the juvenile justice system. One reason I say that is because dependent children need dependency services, especially our teenagers. They're getting independent living services. Those independent living services that are not only statutorily required, but are required for appropriate maturation and prepping for transition into adulthood, are best provided by people who understand exactly what dependency is all about, the needs of youth in dependency, and understand and have access to their caseworkers and their IL staff. Their independent living staff can provide them on a regular story. Let's see. Yeah, I said tell the story. I can't emphasize it, and it sounds almost unlawyer-like to just go tell the story, but it really does count. It really does count, not just to the parties, but the decision maker, the judges. The judges are aware of these stories, and some of them aren't. Especially, as I'll talk later on, if you end up in adult court. After there's been a commitment or after there's been a adjudication of guilt and they're placed on probation, what can you do for your youth who's in dependency and on probation? Make sure that you're in touch with the probation officer, but when the probation is being set up, make sure that the probation, because your public defender may or may not be aware, and the state or the prosecutor may or may not be aware of the living situation of the youth in group care. And so they'll give a standard order of probation which says their curfew hours and where they can go and where they can't go. A lot of our youth in group homes, though, have group home outings, are not always going to be home at 10 o'clock, not because they don't want to be at home at 10 o'clock, but because the van that they're in to the group home outing doesn't get home until 10:30. And if the probation officer calls the group home at 10 and your curfew is at 10, and they call at 10:15, is Johnny there? No, Johnny's not here. That could lead to a violation. What they haven't figured out is, yeah, but Johnny's in a group home, and the group home has every month meetings with its companion group home across town where they engage in activities. So make sure that the terms of probation are reasonable for that dependent child. If you use ankle monitors, kids in care get changed. Their ankle monitor puts them down as this address. The dependency system changes their placement to another foster home. They move because they were told to move, and they get violated. So make sure that that's the role you can play. You understand what's happening in their dependency system. Also, hours for counseling. If they get community service hours, a lot of kids in care in the community get community service hours. Go do X number of hours. Just do them. And that's all they do is do their hours. But a lot of our youth in dependency are also in settings in foster homes or in group settings where they're getting counseling, individual and group. What I ask for is let their time as an incentive for them to encourage incentive, and also because you can only do so much in 24 hours. You can only do so many hours and so many counseling. If it's 50 hours of counseling, then I'm going to say, Judge, I'd like a 2-to-1, 2 hours of counseling is 1 hour community service. So they get credit towards their community service by going to counseling, going to group and going to individual counseling. That's something super concrete you can do for your youth. They're going to counseling, they need to go to counseling, and they should get credit for it. Okay? Showing up to hearings, making sure that they're transported by your lead agency. Their caseworker has arranged transportation. The other thing you can do, which sometimes, with the exception of the public defenders here, because they're really on the ball, we don't always tell our kids how to dress, how to show up, how to be prepared. You can do that, you know. And when the boy walks in and he's got his pants down to here, it's okay to say, pull your pants up, tuck it in. I don't have a belt. That's okay. Tuck your shirt in. And then they'll do this, inevitably. You tell them to pull it up, and they pull it up, and then just before they walk in, they go, and they pull it down. Tell them to keep your pants up. No gum, dress appropriately, be ready for the hearing. And sometimes your kids in care may not always know or remember who their public defender is. What you can do if you know them is make sure they know, make sure they've communicated, and if for whatever reason, because they've been bounced from shelter to foster home care and they've never made an office visit to the public defender's office, and that court date is right around is 30 minutes, pull them aside and say, look, I need you guys to talk. I need to introduce you. Those are the very concrete things you can do for the youth you represent. Because remember, they don't have active parents. If they had active supportive parents, it wouldn't be in dependency. And their caseworker is not always their active parent. You're not their parent, but you can be their active advocate to make sure that they're prepared for that hearing and showing up. Let's see. Once a child is in the Department of Juvenile Justice, remember, just because children are committed to the Department of Juvenile Justice in a commitment program or even adult jail, that doesn't mean they're no longer dependent children. Dependent children are dependent until they turn 18, in which case they're eligible for foster care, or they're adopted, or they're reunified. But they're still dependent children otherwise. So one of the things you can also do is remind everyone and advocate for your youth that they still are entitled to all the dependency services. I have a youth who's been direct filed. He's in Broward County Jail, and one thing I did with him was also advocated with the public defender and got him juvenile sanctions. So he's actually going to he's going to a maximum. He's going to a level 10, which is, someone else said they've seen it only a couple times. This is pretty rare too. But his charges his charges are very serious. And so at least by sending him to a level 10 as opposed to the adult prison system, he'll be again advocating for my dependent youth. I'm saying, you know what, put him in a place that's designed for youth, because he has independent living that needs to be addressed. He has education that needs to be addressed. He'll get his education in the prison system to some degree or other. But when you start talking about independent living and you start having your caseworker calling up and saying we need to have an independent living staffing, you're not going to get anywhere with that in the prison system. But in the juvenile system, you will. And I go to my dependency judge. If my caseworker won't do the independent living staffings as he gets closer to turning 18, if they won't do it, I go to the judge and say, Judge, I want it to be ordered that the department has to have its independent living staffings on time and in place. And if it's local, like in the jail, we can all go to the jail and have an independent living staffing at the jail and bring everyone. The youth needs to participate in that. They're not, just because they're out of sight, they should not be out of mind. Also, adult court pre-filing, same thing. Go tell the story. Tell what the supports are. Tell what the needs are. When this youth was, before he was direct filed, I asked not to have it direct filed. It got direct filed. And then I went back and said, okay, and then after he was sentenced, then give him juvenile sanctions. And here's why. Because he desperately needs the whole, when you go to chapter 39, 701, it talks about there's that list of 10 items that that are required to be provided for the youth upon aging out. Medicaid card, birth certificate, Social Security card, clear understanding of where they're going to live, extension of jurisdiction, RTI, and it just says RTI, don't forget transitional and aftercare benefits. That all has to be provided, and that's best provided in a juvenile setting. So that's what I asked our state attorney, and that's what I went and just said this is why, because that's the place that this youth, who is still dependent, and he will age out in incarceration. And I have reminded his caseworker and our IL staff that it doesn't matter. When he ages out incarcerated, he is an aged out foster care youth, and when he eventually comes out of incarceration, guess what? He's eligible for independent living benefits, and he needs to be provided those independent living benefits. And that's what you can do. Also, PDR staffings, the predisposition report staffings for DJJ, you can show up at those too and tell the story. Tell the story that if you're not there, the DJJ staffing, what are they called? The staffing commitment manager. The commitment manager will never hear and will never know. They will not hear that. They will not hear the background. They will not hear the services. And sometimes getting that information sways the commitment manager one way or the other. Hopefully one way. It'll sway them, but it does work. I have 2 commitment managers in Broward, and you can impress upon them why a lower level in the community is so much more appropriate. Speaking of in the community, when we remove dependent youth, removing any youth from his or her community is bad enough, but you have a youth who was removed from his or her home, they still have attachments to the community. How many of you have ever met a dependent youth who says, yeah, I don't care what part of Florida I live in. I've never have. I get youth whose parental rights were terminated for egregious abuse, and guess what? They'll still tell you, oh yeah, this is my neighborhood. This is where I come from. Even though they've been in group homes all throughout the state. Where do you want to be when you come back to Broward? I want to be in this neighborhood because that's where my people are. So when we remove, when you go to the commitment manager and let them know, this child needs to continue to live in his or her community. That's why we need to be seeking a level that can be accommodated in our community and not sent halfway around the state. And if we want to put families, the commitment managers don't understand goals, we may have a goal of reunification. If the goal is reunification and you place a child from a poor family a long way away, we're guaranteeing there's not going to be reunification because they're not going to have the family counseling, they're not going to have the parenting classes, they're not going to be able, the mom's not going to be able to participate in those activities. It's unrealistic to think that a lot of our parents can just pick up, leave work for 2 days, and drive 10 hours just to go visit their child. So we need to be making people aware that there are ramifications, very hurtful ramifications, to removing children far away. You can do that with your commitment managers at your PDR staffing. Ask to get invited. You can do that at sentencing. You can do that at every stage. But if you don't do it, chances are nobody else is going to do it. No one else is going to do it. No one else is going to stand up and, I shouldn't say that, many times, no one else will do it. And no one else will remind that this child comes from a specific community. She lives in this community. She goes to school in this community. She's part of this community. And she's going to be returning to this community. Barriers. When I started this work a long time ago, some of the barriers, and I guess some of the barriers you'll run into, is people don't understand who you are. You're a what? You're an attorney, a what? And you go to the delinquency hearing and they say, no, this is delinquency. We have two parties and only two parties, the state and the defense. And why are you standing at the podium? And what are you talking about? All this dependency nonsense. Just go. Show up. Inject yourself into the system. Be there. Introduce yourself and know that you have a legal right to be there as an advocate, as an attorney for the child, and more importantly, you're doing the right thing. The child is voiceless, and the reason you became attorney ad litems and took on cases is to give the child a voice, a meaningful voice. Show up and don't hesitate just because someone says, there's only two podiums. I go to my delinquency courts, not our crossover courts, but I also represent some youth, or I show up when they're in delinquency court, and there are two podiums. Where do you stand when you're the third? Or in our dependency cases, in fact, we have 2, maybe 3 tables. One for the attorney generals, one for the parents, and one for the guardian. You know what I do? If I get there first, I sit down. Sometimes the department, your lead agency will recommend, they'll have a staffing to recommend something, and then they always say, like it's the golden rule, they say, well, we recommended, we had a permanency staffing, and our recommendation is. I once was so irritated that I said, well, I staffed it too, and I came to a different recommendation. So grab your chair, sit down, interject yourself. Politely say, I'm here for the child. That's a barrier. Another barrier is working. Make sure that you have a good relationship with the other folks. Be polite, be civil. Obviously, that's how you get around. But be firm and understand the different roles, and make sure that the other people don't understand the other roles. A lot of times, caseworkers, guardians will say, "Oh, how can we all know Johnny's going to run. As soon as Johnny gets out, Johnny's going to be gone. He even said so himself. And every time he said so, he always does. How can the public defender argue for him to be released, that it's an unlawful hold? Well, that's because they don't understand the role of the public defender. So make sure that everyone understands everyone's role, and your role as an attorney ad litem is to advocate in the dependency, but everything affects his dependent life. You can't really compartmentalize it. The legal interest and the expressed interest of your client after having been counseled. That's pretty easy, but make sure they understand that. And you'll get people too who will say, "Oh, your client's going to run and it's going to be a risk. You know that, right? You can't let him out." Well, that's not your role. And make sure that they understand if they have those concerns, they can bring those concerns to the table too. But don't expect them. You should not expect. Hopefully, they don't expect you to bring that to the table. Office visits with public defenders. Have them transported. I agree. Just say, look, you take them to the doctors. You are the legal custodian of the child. If the child needs to go to the doctor's office, they go to the doctor's office. If they need to go to the public defender's office, they go to the public defender's office. You are the legal custodians, and trust me, all of our lead agencies have money for transportation. And if the case manager can't do it, they have people that do nothing but transport. It's part of their contract. When they negotiated the contract with the Department of Children and Families, that should have been, if it wasn't, that's their mistake, it should have been built into their contract that they provide transportation for youth. Well, I think I already went over the mitigating information. You know it, and you can bring it to the diversion, the charges, the court. Don't hesitate in the rare cases, and hopefully it doesn't happen, but if you do end up in adult court, you can go to adult court. I had a youth that I represented who had just aged out. I do an extension of jurisdiction. I continue to represent youth, who was in adult court, and he was facing the possibility of a violation of probation. And the state was gunning for incarceration, for prison. The public defender was obviously against it, but didn't really know what they could argue because he technically did violate probation. Technically violated probation. What I did was gathered the facts from him and his his mental health provider, and I showed up in court and I said, Judge, you need to know about why he violated. Did he technically violate? Everyone knew that because that's the way it was. But he was on a bus going to his mental health appointment, he was on a bus coming from the mental health appointment, and it ran late, and he had called what he thought was the appropriate folks. And I said, Judge, he's got his supports in place. He's aged out of the system, but he's in transitional independent living housing. He's got a therapist. He's compliant with all these things, and he's got a job, and he's going to school, and he's doing everything that we ask of him. And the state has just asked you to put him into prison, but that's not right because he's doing everything that he said. I called the right people. I thought I was doing what I was supposed to, and I'm going to my counseling, which I need. And because I was there, not me, but because someone raised that to the court, judge said, you know what? You're right. I'm going to reinstate probation. Sending him to prison is a waste of everybody, especially his life. So show up and argue that. Let's see. Working back. What does that mean? Oh, working back in the big picture. Sometimes working backwards. If you notice that your dependent youth are always getting arrested at the same place, maybe you need to go back and see what's going on at that place. There were some group homes that I worked with. 2 of them don't exist anymore. That included in their treatment milieu referrals to law enforcement. I don't understand that, but that was a huge problem. And when you start to see that your client that you're representing, every time they're placed at a certain placement, gets a charge, maybe it's not just your client. Maybe there's something else going on. And so you can look at that, and you can also bring that together as your crossroads a pool and say, look, maybe this is an issue we need to look at, and maybe there's something going on. You can talk to the public defender, who's also going to say, yeah, we realize a lot of kids coming from this place with charges too. Another thing that we've been very successful with as attorneys for children in dependency is some of our group homes. We've reached out to the law enforcement agency that covers that group home area. And we have several law enforcement officers now, agencies have assigned specific officers to that group home. And those officers have been invited to come to trainings, invited to learn about dependency system, and I'll tell you what, at those group homes, the arrest rate has gone way down. I have a youth that I represented who had a fake taser, and it was a flashlight. He whipped it out, he brought it out, and he was swinging it around the group home. The law enforcement showed up. If it was any other officer, and I told my kid this, I said, you probably would have taken a bullet if you waved a taser around like this. But because we had developed a relationship with the law enforcement that oversaw that group home, and he went out of his way. This officer goes out of his way to get to know the youth. When he showed up, he was like, "What are you doing? Why are you doing this? Silly boy, put the thing down. Let's talk. What's going on?" And they resolved the problem. Now that was obviously something that was not done overnight. That's been a long process to come. But that's reduced involvement in the delinquency system too. Let's see. Oh, recently, Safe Harbor Act. Safe Harbor Act for children involved in human trafficking. When children are arrested or law enforcement shows up and children are involved in acts of human trafficking, they're not to be arrested, they're to be treated as victims. But there are safe harbor placements. If your children that you're advocating for are caught up in human trafficking, make sure that they get the appropriate services, and that might include placement into a safe harbor placement. Running away is such a. Let people know if let the JPOs know. Really, it's not an abscond. They were at the. I remember this. I was on a case where the home even said, "Well, we know where she was. She was at the stop sign at the end of the block, but she's off the property." And the JPO is saying technically it's a violation, and our judges don't like that. Our judges don't want to hear, "Really? It's a violation. You're taking up my time on my docket, and you're going to charge this kid with a violation of probation when she was at the stop sign down the road." That's a little bit unfair. Another thing you can do for your youth who are involved in delinquency is continue their contact with their families and their siblings. If they get committed to a juvenile justice department and they have siblings, chances are very good that no one is going to say, "What are we going to do to keep up sibling contact?" Parents will go visit, but siblings don't go visit. I represent two brothers. One is 2 weeks ago got accepted to the University of Florida, which is coming out of foster care. He's going to UF. The other brother is in the middle of the state in a program. That's all they have for family is each other. And everyone wants to say, well, the one bad brother needs to have contact, needs to be a role model. I mean, the bad boy needs to see his other brother as a role model. I've gotten to know them over the years, and I realize good, bad has nothing to do with it. They're brothers. All they have is each other, and they want to have contact with each other. So I've had to arrange transportation. I've had to arrange the transportation. I've had to arrange that the siblings be able to visit each other on family day because they're not a parent. DJJ gets thrown by that. They say, "Well, who are you? You're not an adult. You're not a parent." So do that. Keep those family bonds going. Keep the arrangements going. And don't forget, if their kids are in care, they're still in care. And they still need to be provided that services and those supports. Let's see. I got to wrap this up. Travel orders. I have signed travel orders for youth in care. Another thing is an attorney ad litem. If they're in a DJJ commitment program, you can also get them court ordered to be transported to their dependency hearings. I have youth who are transported 8 hours to show up for dependency hearings, especially if it's their aging out hearing, their benchmark hearing. I want them present in court. And get that order signed. Have them transported. I've had youth transported to family funerals. And I'm going to have probably for those two boys I just spoke about, I'm going to ask for the one youth to be transported to his brother's graduation. Now, keep in mind, when you're incarcerated as a juvenile and you're out in public, you're in shackles and cuffs. That's department policy, and it's pretty unwaivable. So if you bring your child, talk to your child. If they go to your mother's funeral, you're going to be in cuffs and shackle. So what I do is I bring clothes. I go to the detention center. I throw over a coat. It hides everything pretty well. But some of the youth will say, "I don't care. It's more important for me to go to my mother's funeral than it is to worry about what the other people in the church are going to think about why I'm wearing chains." So that's an advocacy. If you don't do that, no one else will. Sibling visits. I've arranged for sibling visits between Broward, and Titusville with a child in a program. Just do it. Arrange it. People say, really? You want us to go through all that trouble? To drive drive two of the girls from Broward up to Palm Beach and this girl and the Department of Juvenile Justice down? And the answer is yes, because I would like to visit my siblings, and it's in the statute as well. It's a goal of children in care is to have regular sibling visits. Get a court ordered. Most of your judges will back you up on that. And out-of-county placements, I already said that that's just terrible. It ruins things. The other last thing is, don't forget, pursuant to 390132, subparagraph 6, dependency court records cannot be used as evidence in other civil or criminal proceedings. So I like to remind people all of that. If there's discussion of drug use, if there's discussion of all that in dependency so we can get services or so we can help kids out, that information, you shouldn't be taking that order with all those findings willy-nilly off to the delinquency court. It's not admissible per statute. So prosecutors shouldn't be using dependency as a fishing what do you call it? Expedition, fishing expedition, exactly, because the roles are different. Even under Unified Family Court. Unified Family Court doesn't say we blur the lines. It says we bring together what we need to for the best interest of the child and the safety and well-being, which includes emotional and physical well-being, but you don't blur the lines completely. You still have distinctions in evidence, and rules of evidence should not be ignored. Anything else? Any questions? I know we have one more speaker, and ooh, I'm in trouble. Any questions? No? Y'all want to go home? Okay.
Little bit about us. Department of Juvenile Justice, our new secretary, has gone on some roadmap. She's gone around the state for touring. She is rehauling the whole Department of Juvenile Justice. We are looking to make it a model for juvenile justice reform. She has been extremely aggressive in reallocating resources, putting services on the front end, closing down detention facilities. So one of the roadmap goals, prevent more youth from entering the juvenile justice system. Most of our services were always on the back end. We then realized we're making a mistake. We got to prevent these kids from coming into the system. So the Department of Juvenile Justice funds boys clubs, PACE Center for Girls, and civil citation programs. And we talked about civil citation. Hillsborough County was one of the first counties to start a civil citation program. We started about 2 years ago. It's now mandated by the legislature that every county shall have one. Not all counties have cooperated. But we started with all of our youth in the school system. We were getting too many school referrals. So battery, disruption of a school function, criminal mischief. So civil citation came about because of the number of school referrals that we were getting. We then expanded it to the community. So it's a way of preventing our kids from getting a record. Once you get fingerprinted, it's sent to FDLE, and in order to get your fingerprints expunged, you have to go through a process, pay the fees, and if you're not very experienced with it, it's not easy. So civil citation, you're never fingerprinted. You're given a citation, you get community service hours, apology letter, you could be ordered into counseling, you get some type of assessment, and it all is at a cost savings to taxpayers. It costs $5,000 to put a kid through a system for judicial processing. Civil citation costs $386 and you don't get a record. Many of our kids, first thing they ask on college applications, have you ever been arrested? So we're really hurting our juveniles when we don't have something like civil citation in place. Hillsborough County only does 7 charges. We're trying to get that expanded. They don't include drug offenses in it. but we're looking to work with the state attorney's office and law enforcement and hopefully expand our civil citation programs. So, secure detention. Hillsborough County is part of a initiative for juvenile detention alternative initiative to reduce our detention population. I'll go further into that, but we talked about diversion programs. This is the amount of diversion programs we have in Hillsborough County, and because of our public defender's office, that is fabulous, and we have great stakeholders in our community. Judge Stoddard, many of these things came out of our juvenile justice boards. Marie participates on the mental health court. We have drug court, SINS, FINS, Prodigy, sex offender walker plan, and these were all developed within this county. We have a huge amount of resources for diversion. All our kids go through the juvenile assessment center, or about 90%. They are diverted right out of the top. They come in. If you don't meet the secure criteria, you then go to the diversion side. State attorney gets the recommendation that youth has limited history and can benefit from diversion. And then our court administration also runs many of our diversion programs. We have neighborhood accountability boards along with civil citation. So our kids here are fortunate. We try to keep the kids out of our system. Secure detention. If you put a youth in detention, more than likely he will recidivate. When you put children in detention, research is showing the risk to reoffend increases. You're hurting the aging out process. You're disrupting them from school. You're disrupting them from their community. So the department is working on only putting our public safety risk youth into the detention centers. Hillsborough County had 2 detention centers. We now have 1. It's a 90-bed facility. We have 68 youth in there. That's our average population, and we're trying to even reduce it after that. So, but one of the problems with detention, mostly 60% of our kids are in there on court orders, pick-up orders. That's what we are trying to look at, and if they're not a public safety risk and the judges agree to it, we're looking at having some type of reset. They're picked up, they're brought to the jack, they're released on home detention, they go to court the next day and they don't have to spend time in detention center. This is 40%, 7% of our admissions to secure detention were related to court orders. So we're working on a failure to appear work group along with the JAC release program. Using secure detention only when necessary. JDAI, Broward County's part of JDAI. This is done through the Casey Foundation. It's a national organization, Annie E. Casey. I don't know if everybody's familiar with it. They look at-risk youth and also best practice. But the purpose of secure detention is not for punishment. It's to provide a safe place for youth who are at risk to public safety or might not show up for court. So with JDAI, we are looking at youth that are public safety risk, keep them in there. But your kids with court order, pick-up orders, let's release them, put them on EM. We also have a monitor that we recently hired that can visit them at home. And if for any reason, and we also have EM. We mentioned EM, that's one of our JDAI initiatives. One of the other things they have, the detention risk assessment instrument. That is how you score for detention. It's statewide. In 1994, it was a group of public defenders, state attorneys, judges, law enforcement, all determined how we were going to score youth for detention. So in the DRE, which they are looking at reevaluating, are we putting the right kids in detention? But in the DRE, there is one of the things is you may score on the underlying charge. If a kid is brought in on a misdemeanor, but he has a serious record, they would then look back at his record and that would give them enough points to score. But some of our kids have come out of commitment programs and their history always hinders them. So they might commit a misdemeanor, come in, and because they had a history in the past of being in one of our programs, they would normally score for detention. But with the DRE underlying pilot, if the underlying offense is within the first year of the youth's placement of a violent offense, if the youth had a violent offense within the last year, then they would score him, or 90 days for nonviolent. We also have a domestic violence pilot going on. I know we talked about parents that don't want their children. Hillsborough County has the highest rate of domestic violence in the state. So and usually with domestic violence, first thing the parents say is, I don't want them. You know, you take them, you lock them up, I don't want them home. So we have contracted with a family network center, which is Lake Mag, and if a youth is charged with domestic violence, they go to court, the judge, if the parents sign the consent forms, they can then go to Lake Mag instead of staying in detention. We've had 35 kids, we've had more, but out of the 35 kids that we've had in the program, only one has recidivated. And with the domestic violence program, they provide wraparound services. It's up to 14 days of wraparound services, and then they're released to the community, and the wraparound services continue. So we're real excited about that. And everybody knows with the parents, once you get charged with DV, if they refuse you, it could then put you in the foster care system. And, you know, you just end up going deeper into the system.
Could you, out of how many?
We have 35 families, only one recidivated with the DV program. We're real proud of this program. Yeah, and actually they started, because of the one in Hillsborough County, they just implemented it statewide. So certain counties have beds that they can contract with their local shelters for kids charged with DV. And the problem is normally the shelters won't take youth that have judicial records. So this allows our kids to go in there, get the bed. And, you know, domestic violence is not a community, you know, it's not a community safety risk. These kids are coming from dysfunctional homes, substance abuse problems, everything else. And all they need is services.
Will PJ transport them if the families refuse to transport them to Lake Magdalene?
Lake Mag picks up. If they are ordered in, if the parent will sign the consent forms, and the problem is we will do it at the Jack if the parent agrees to. Usually they're still hot and they don't want the kid to go there. It usually takes the next day with Judge Stoddard or one of the judges to talk them into it, and then Lake Mag will come pick up the youth. So an Yvette or someone in court will get the paperwork signed. Using secure detention only when necessary. We're decreasing the number of youth admitted to secure for failure to appear. We have an auto dialer system. It started in Hillsborough County. This is another thing that Hillsborough started. It's now in every county in the state. It reminds kids of their court dates. It contacts them. Now some of our kids, we know, their cell phones are cut off, every week. They never have good cell phones, or the numbers are disconnected. But we have a 96% success rate on it. It either calls a machine, a cell phone, a grandparent, anybody we could on the contact sheet or information to try to remind them that they have court. Another way of using secure detention only when necessary, we talked about VOPs by the probation officers. Well, the department wants to cut down on technical violations. We are implementing an effective response system. Hillsborough County is also a pilot. I haven't talked to the judges about it yet, so we haven't really started it. But it provides probation staff with alternative sanctions. Our staff are told they have to exhaust everything before they file a violation on a youth. Now, some of our violations, if they're chronic, curfew, school, they have to be brought back to court. But if there is a way to implement services immediately and avoid the violation and maybe notify the court by a non-judicial letter, that's something we're working on. The Department of Juvenile Justice has been all over the map, and everybody that knows and has worked with us, we've been law enforcement, we've been rehabilitative. I think we're finally back to happy median. But it also, where we're at now, also takes working with your staff to get them on board. At one time, we were brokers of services. We didn't go out into the community anymore. And, you know, people were like probation officers, you know, you're in-house. And probation officers were working 8 to 5. The budget was bad. There was no travel money. So many of them got used to that. We have now redefined their positions. They're going to be signing new position descriptions, non-traditional hours, and they have to get back out in the community. They are the one, like you said, these kids need someone to work with and someone to hear what they have to say. That's what the probation officer should be doing. So they're all being trained in evidence-based programming. We have life skills, ART, which is aggression replacement therapy, and we also have T4C, which is another evidence-based program. So they should be looking for satellite offices for our kids that have problems getting into the office or out, you know, that are located in Waimama and don't have any transportation. They're supposed to get satellite offices, though, that they could hold these groups and to make it easy for the families to report in. Residential commitment. Our residential commitment has gone down by 44% in the past 5 years. We had 3,100 beds online. I think we're down to, we've reduced it to almost half. The idea is we don't want our kids in deeper end services. Once you commit a youth, especially a low-risk youth, a misdemeanor, or someone that's committed a technical violation, he is more than likely not to be able to make it out of the system. They will end up deeper into the system. This is what the research shows. So we are looking at exhausting everything we can do before we put a youth in a commitment program. And like I said, especially youth that are identified as low or moderate risk to reoffend, if you put them in a program, there's peer deviancy training. They will learn from their peers, and more than likely, they will become higher risk to reoffend. How do we ensure appropriate utilization of our residential beds? You know, we talked about the commitment staffings, and it's the importance of being there and advocating for your client. We are also using a dispositional matrix. Statewide, we want to get everybody on board on how they're disposing of cases. Duval County shouldn't be putting kids in commitment programs left and right, while Hillsborough, you know, is the opposite. So that's being piloted in Circuit 6, and I'm sure it would be expanded to other circuits shortly. We are piloting the effective response system. That has to do with filing technical VOPs and working with the kids. Probation also has redirection programs. That's family functional therapy or multi-systemic therapy. We have FFT in Hillsborough County. If you have a youth that's having problems at home, not doing well, if you think you're going to be filing a violation and putting them in a residential treatment program, we have therapists that will go out to the home and work with the family. So that's one of the things we've had about 2 years. They're expanding, and it's been fantastic. Probation enhancement services. They're taking the back-end money, all the residential beds that we had, we're putting the money in the front end. Probation enhancement services would be our electronic monitoring. They would be counseling, substance abuse, getting monies, rate agreements, or kids that can't afford to have their drug screens or their evaluations. This would put rate agreements in place so that it would help our kids complete their sanctions. We could pay for their counseling. We could pay for their drug screens. We could pay for them to get the services they need to work their way off probation and become a productive citizen. We also have day treatment programs. In Hillsborough County, we have Paxson. It's open from 3 to 8 p.m., and that's the time when kids reoffend. They provide evidence-based programming. They also have a GED component linked to it. So if we have a youth that needs stricter supervision, instead of looking at residential, we can put them in day treatment and have them supervised daily. Whoop, I backed up and I can't. Okay. Well, our highlights. We have a prevention pact. This is used for a civil citation kid. And the pact is our positive achievement change tool. It's an assessment that we use, and it identifies, it has 12 domains on it, and it will identify what a youth needs. Is it education? Is it life skills? Is it mental health? So we want to expand the use of our pact. We want to increase our delinquency prevention programs during the year 2012-2013. Reduce the percentage of minority youth referrals. And I don't think I mentioned this, but our minority youth make up 21% of our population, but they are 50% of our kids. And as you go along on the system, if they might be 50% on probation, but then they're 54% in residential treatment programs, then they're 60% direct filed. The deeper you go into the system, the more you have minority youth. So we're trying to concentrate on that. Create a liaison. I think Judge Campbell had a DMC work group going. We're also looking at minority youth that go into detention, higher numbers. How can we put them out on EM and reduce the racial disparity? So we want to increase the number of youth issued a civil citation. Plant City has not done any civil citations, so we have to work on them. That's our next target. We have to go after them and reduce the number of school referrals. We have in Hillsborough County, we were number 1. I think we're now 19th, but it's come way down. Divert 10% more youth. This is, and like I said, these are all the Secretary's agendas for items for this year. We want to decrease the number of youth who are low risk to reoffend and placed in secure detention. Increase the daily use of EM units. Hillsborough has about 17 units. I'm not full yet, but our JDAI initiative should start shortly, and that we're looking at kids 12 and under that are coming into detention. We can put out on EM. We're also looking at kids charged with property crimes and pickup orders. Instead of putting them in detention, we could put them on electronic monitoring. Expand JACs. Hillsborough has 90% of our kids go through the JAC. That's when they'll be siphoned off, whether they go into secure or whether they could get a diversion program. So we've added one more staff to try to help out with civil citation at the JAC Center. And then redesign and expand community alternatives. Talked about reducing recidivism of youth to complete residential treatment. One of the things that we're not doing well in, kids that are coming out of residential, we have a 64% recidivism rate, and that's not good. So we have had a provider that took over as a JPO. The JPO will now be taking all the cases back. With the $11 million that we're saving, we're contracting for services, wraparound services, mental health services, independent living. So many of these kids that come out of commitment programs, you'll know, like your foster care kids have nowhere to go. Some of the money could be used to set them up in an apartment, to give them, education. So we have to do a better job with transition. We have reentry boards now that when the youth comes out, they'll be staffed with education, with if there's a faith initiative partner, any kind, we work with the workforce board. So we are not doing well with our reentry youth, and we need to improve.
Can I add that if it's a dependent, he or she's a dependent youth, obviously part of that reentry has to be the dependency system. And if they're pre-18, all regular dependency, if they're post-18, they're independent living.
And if they come out of foster care, the problem with that is they don't know till the day they're released or the day before they're released where they're going to be living. So you can think you're having a kid coming back to Hillsborough County, he could end up in Jacksonville. And
you can help that by reminding your caseworkers that Susie comes out in 4 weeks. We know it's coming, the date's coming, what's going to happen. Push it, because, yes,
and even though you do, what happens is the CBCs have to pay for that bed to hold it for that youth.
But they can start looking, and sometimes they don't start
I
looking
agree.
until, oh, someone's back in county.
Yeah. So, and you know, in the whole transition process, you're getting the school records. You're trying to place them in a school, and it disrupts everything. And then, you know, some of these kids are thrown on your doorstep that day, and they're back in your community. So, I just gave you some figures here for referrals, probation referrals. For the last, since 2007, 2008, we were at, and I don't have my glasses on, I didn't grab them, I think it was 2,000 kids on probation, and we're reducing it slowly. I have referrals for commitment. This is where we're doing really well, 44% reduction. And like I said, we only want to put our deep end youth in residential commitment. And we're also looking at, as we reallocate and re-engineer our beds, substance abuse, mental health, sex offender beds. I mean, we have to be smarter about what kind of residential services we're providing. So many of our kids have mental health problems, and we need mental health beds. This is our direct files. And we are working with Judge Stoddard. We're going to try to educate the adult court judges. We brought up the fact that a lot of kids want to be on adult probation. You can't make adult probation when you're 16 years old. You're not going to make it on adult community control. But I think the department, instead of putting these youth out in the community, if they've done something serious, the Department of Juvenile Justice can put them in a commitment facility, can keep them as a juvenile, can give them their vocational training or their education, and they will be off the street 3 years versus going adult, being put on probation, community control, and violating. So it's something I think the adult court judges are unfamiliar with, and we have to do a better job of educating them so that our kids don't end up in the adult system and sentenced as adults. And that's it.